We have other questions. Senator Gaines, did you complete your questions?
I think the only comment I would add is when we look at CEQA exemptions, the reason those exemptions come forward is because we haven't reformed CEQA. And so, you know, if you were able to reform it, you wouldn't have these bypass attempts occurring that come through the legislature. And my feeling is that you would exacerbate that by setting precedents with this piece of legislation, which has impacts not just on coal, it has impacts on the entire California economy and our ability to provide housing and even approval of, I would think, any project that has to go through a CEQA process for approval. So that's my concern.
Well, when CEQA has a controversy, generally the courts, maybe some of the attorneys can correct me if I'm wrong, but generally the courts allow the controversy to be determined by the public process, and they lean towards allowing a discussion through a supplemental EIR process, and the courts are then, they generally dictate that a supplemental EIR, and they make a ruling that the supplemental EIR be accomplished by the lead agency, which is the city of Oakland, which is
we don't know right now.
Okay, well, that's something
Contract dispute.
Okay, there's a dispute. Okay, we'll leave that on the table right now. But when there's a controversy, generally the courts lean towards, in CEQA lawsuits, that the controversy be resolved by a CEQA continuation, amendment to CEQA. The controversy, when those things raise, they say significant bodies that have expressed an interest on the issue. This could include the fact that we have two mayors coming from two of the surrounding input cities. That would be very important to a court, that the mayors from a surrounding city have expressed an interest in the controversy. I think just on that alone, generally, they will order, it's a local government that's adjacent, they will order some kind of review of the process. We have other entities that, you know, the employees of a large employee organization representing a large number of employees that are working in the area. That's important. So I think and then the state of California, the EPA, other agencies weigh in also. I think generally, if a judge saw this with that many people coming up, they would say, go ahead and do another supplement. Am I right?
Senator, in fact, your comments that you just made together with the housing example you gave is exactly right. And that is why this bill is not required, because CEQA already would require that to happen in the circumstances.
We're not seeing anything happen. That's the question I have. We're not happening.
But CEQA, that comes with the broadest private right of action of really any law that I'm aware of in California, gives everyone the ability to go to the lead agency and say, you have not done what you're supposed to do. And like your housing example, if the project has changed, if I'm adding units to my housing project, I do not have an approval that covers the development of that project. So I could not build a 400-unit project if I only had 200 units in my EIR. And similarly here, if the project proponent—
Do you agree if we had two mayors, you know, the bodies that are next to them representing, what's population of the two cities combined, Senator? A couple 100,000 people? I mean that's
over 100,000.
Mayor says yes. Okay. I would say if two mayors came and testified at a public hearing on a subject like that, that would, I mean, you got to do the supplement. I mean, you know, basically, you're not, there's not going to be any question about this. You know, this is kind of a clear kind of situation.
Mr. Chairman, you're right, but that's also a court of law that it's a lot longer process than this hearing, right? So,
Well, we can hopefully, my feeling is, Senator, is that we're not hearing anything from the city of Oakland, okay? Or that's the problem. That's our problem.
The problem is the city of Oakland is looking for recourse. They have passed a resolution against coal. They've been told that they have to make certain findings or the developer will sue them, and they've been told by their city attorney they can't comment right now.
Yeah, okay, then
And I think that it would move things forward in a much more linear way if this body would indicate that there needs to be a supplemental EIR when and if a permit is requested for the coal depot.
Senator Bates has the floor.
I just want to bring us back to the purpose of CEQA and the supplementals that go on. Having served at city council level and board of supervisors, you do a CEQA process to determine what mitigation is required to let this project go forward. I think we heard that there are mitigations that have been required by the federal government, EPA, so you know that coal already has a very elaborate mitigation requirement as it passes along the rails, I'm assuming, based on what you said. But bottom line, what I'm hearing, we have already compromised the CEQA process through a supplemental by making it very clear that the purpose of it is to stop coal transport through the city of Oakland. And you've said that in testimony. We've heard that. The resolution is there. So this already sets, I think, the stage for a protracted litigation on whether this is a legitimate supplemental EIR or intended through the mitigation additional that would be placed on this to stop the project. So just in good conscience, I could not vote for it because it is no longer the open, transparent process that it was intended to be when projects are presented to local government. And the local government, as far as I know, has all the authority to require a supplemental. It doesn't have to come to the legislature. And if that's what we're going to open the book on, we have compromised the CEQA process even more. And I think those of us who've served at local government that have dealt with those projects, be they the 200 unit that expanded to 400 to perhaps address affordable housing, whatever, we have done due diligence in determining whether a supplemental should be required because we're looking for additional mitigation that might be required to ensure that the project does not impact public health and safety. But when it is intended to stop a project specifically for that and raise the mitigation level so high, you're going to go to court and you're going to find out based on the testimony you've put on the record that you've already compromised that project. And I just couldn't vote for it on the basis of that. And I'm not a big fossil fuel, fan, but if that's what we want to do, then there's a different avenue to pursue, and that's to outlaw coal production. If that's what we don't want coal, then let us go down that. But don't try to use this process, which is already so encumbered and so compromised that is basically affecting the economy of this state as compared to any other state. I mean, it's being used, and I've, been recognized by environmental groups for my fight for fair environmental review on the coastal issues. So I'm a fan to a degree, but it's very disturbing to see a process like this in this particular piece of legislation that is specifically intended to stop this project and stop the coal transport. There's got to be something back at the local level to determine what the legitimacy is, what the mitigations additional over what they already have should be, and then determine if that's a legitimate request of the developer. It might cost more money. That becomes inconsequential. But, let's use the process the way it was intended and not be using it in a manipulative way, because I think that really is it's just against the democratic process, and it's very troubling.
I think Senator Mendoza has a comment or two. I don't know who else. Anybody else?
Thank you, Mr. Chair. I just wanted to, again, echo some of the concerns that were said about CEQA. I don't think we need to create a special I guess, a separate type of secret process just for certain projects that we don't like. I am disappointed the city's not here, the city of Oakland. They're the ones who actually issued the permits, they're the ones that actually gave the land to the developer. They're the ones who initiated all this, the reason we're here is because of them. And yet they're not here. And we can't ask them questions. They don't want, they have legal reasons why they want to hide or not come forward. I understand that. I do think it's kind of disappointing that we have to do the work for them and try to figure this out on our own without them here. And I do believe that they can actually issue the supplemental CEQA if they wanted. They can actually go and actually ask for this. I mean, I served on local city council. If somebody came in for 100 units of senior housing and they switch it over to family housing, believe me, that's a different use. We're going to talk about it some more, especially about parking. But they have the ability to do that. I don't think we need to go through this process. And I understand where we're trying to go with here, but I do have concerns about that. And what about what does that say about the other ports in our state? All the other ports are exporting coal right now as we speak. I haven't heard from them. I want to know what they're saying about coal, if anything there. And all those ports are near these type of communities that we're just talking about here today. So I want to know more about that as well. And yet we're not talking about that. We're just talking about Oakland, who's not exporting anything. Does that mean that the other ports are going to be exporting more because you guys don't want to? We need to, there's some questions there that need to be answered. And I do have concerns because I don't, if coal is bad, maybe I don't want it to be going through other ports as well. I mean, I don't know. We haven't looked at that. But Oakland's not here. I wish they were. And I don't want to fight their battles if they're not here to talk about it themselves. So anyway, I just have concerns with it, and I don't think I'll be supporting it today.
Any other comments from others? Senator McGuire.
Thank you so much, Mr. Chair. And I apologize about being late. We had Human Services Committee.
You had, I like the fact that you approved both my bills in that committee. So
Hey, thank you, Mr. Chair. Yes, sir.
go right ahead.
So just a few comments. So talking about the original EIR, once again, it didn't evaluate coal shipments coming through. Just want to confirm that I'm correct on that. Okay. And my understanding, and just making sure that I'm on the same page, when asked if coal would be shipped, those involved in the process and the development side, they strongly denied that coal would be shipped through.
May
Well, I'm looking to the senator, and because I've read the media reports as well, but I just want to confirm. So, senators, that's
Yep, they said that they had no plans to ship coal.
Now, when was that?
That was, I think, about 2012. Do you know when? Oh, 2013, sorry.
It was
So after the supplement.
give you the exact.
Yeah.
It was a statement in 2013 when the exclusive right to operate was in the hands of Kinder Morgan, and Kinder Morgan was looking at two particular commodities that it wanted to move through. They had a very strict time frame within which to do their deal, and the city could not accommodate their timing, so that deal was lost. So the statement was true and made. Beyond that, I'm here, Mr. Tagami feels very strongly that the record be abundantly clear that he was asked many times, will you confirm that this will never go through? And his answer, based again on the fact that the market demands a full service commodity and what will be taken off the table 2 years from now, was always, no, we can't do that. We don't have a viable project if we start committing to take this off today, that off tomorrow. So this, other than that one statement in 2013, which was true when made, other allegations of a commitment not to do it are incorrect.
So when asked directly, and again, I'm not trying to make anyone a villain in this, but I just want to make sure I have the facts straight. When asked directly if coal's going to come through, the company said what?
When asked directly if he would commit not to allow it to come through, he said he couldn't take it off the table.
Okay. So he couldn't take it off the table, and the original EIR didn't evaluate it despite the fact that he didn't want to take it off the table.
The original EIR didn't evaluate any of the other 15,000 potential commodities coming through either.
Okay. So I'm just going to, I think we can all come to this with our own personal perspectives, and that's where I'm at right now. So sitting on a board of supervisors, that lives the dream with land use all the time, as well as city council. I want to talk about some projects that came before us that required a supplemental EIR, much less than this. And again, not trying to point fingers, but two things. Number one, a local government can request a supplemental EIR. I have seen developers request a supplemental EIR, or the state does have the ability to be able to request a supplemental. I have seen supplemental EIRs offered for less than 15 additional homes. I've seen a supplemental EIR brought forward, not saying that it is always right at all, but I've seen a supplemental EIR or even a full-blown EIR going from a neg deck to an EIR for a winery expansion project. So I'm putting that in perspective because, look, I would love to be able to see the city of Oakland here, but I think on an issue like this, and for the state that we live in, when it comes to a potential impact that has been described, there is an impact. And there's also public money involved. And we can't forget that. There's over $50 million in public funds that may be used to invest, and why wouldn't we want to be able to protect that investment? And my big belief is, if you're in California and you're doing a large development project, you should look to a process that could cover your backside when it comes to a long-term investment. And to be able to do business in California, particularly for a project that is much larger than a winery expansion and is much larger than less than a couple dozen homes, I would expect that that investment would be made, particularly that we know that there are public funds being used in this project. Now, does that mean that this project would be stopped? No. And I think that Senator Bates is right. People have used EIRs to be able to exploit CEQA at times, but what we also know, it looks to impacts. And I have to say my own personal opinion, and I'm not, again, vilifying any one individual or not, this has a much more significant impact than what the projects that I described for you that I've seen in Northern California. And it wasn't originally evaluated in the EIR. And if this is going to be, and we know the impacts on that particular shipment, why are we nervous about it? EIRs could help you be able to advance a project forward. And particularly these days, I would recommend that that's done. That's just my own point of view, and we'll be supporting the bill here today.
Any other comments from other members? Senator Cannell, you have.
Brief comment. I agree with Senator McGuire, and I'm glad that you as a Board of Supervisor could make that decision for your community. The difference here is that we as the state of California is being asked to make that decision, and that's my problem with it. So.
Mr. Chair,
Senator Roth.
are we getting close to?
I'm asking anybody if they had any other comments or questions of the senator, and then we can make a motion for some way.
Well, then let me, if I could just make a quick comment. You know, first, I'm not focusing or concerned at this point on coal versus no coal. I mean, I think the issue is a process issue. I'm concerned about the constitutionality of this with respect to the Commerce Clause and some other things, although I'm not a constitutional scholar. I'm also concerned about the state intervening in a local issue when it seems pretty clear to me that the locals should be moving ahead with this supplemental EIR, but I do recognize that this is an issue of concern to the author, and it's a significant issue in the minds of her constituents. And so, Mr. Chair, as a courtesy to my colleague who is dealing with a local issue, I will be supporting the measure to get it out of this committee to its next destination.
Is there a motion on this? I'm going to make a motion. Okay. I wanted to first apologize to the city of Emeryville. Where's Emeryville? I'm sorry, I didn't mention you. I mentioned Richmond, I mentioned Berkeley. I'm sorry, I didn't mention Emeryville. They're a city too. And I also wanted to apologize for the Oakland Unified School District, who also is a government institution as well, that has expressed their views. Colleagues, the EIR that was done originally on this project was 10 years ago. It was done under the auspices of another governmental institution. Since that time, another governmental institution took over due to the realignment, redevelopment. And then there was a supplement done in 2012 which didn't cover the issue adequately. So in my mind, we have what we call a stale EIR, an EIR that had not covered the actual project. And I think it's important to have a supplemental EIR. We could pass the buck to the City of Oakland. We could pass it to the courts or do one of those things. But I think the right thing to do is just say, we invested, and I'm kind of going to say this to anybody that allocates state funds. If they have a project, they better be very careful about the environmental clearance for those projects that they approve money for. We should request that an EIR be done. And I hope that the City of Oakland takes the message to the EIR. I would urge support for the bill. So we call the roll. This also goes to other committees as well.
The motion is do pass and refer to the Committee on Environmental Quality. Senator Bell?
Aye.
Bell, aye. Cannella?
No.
Cannella, no. Allen? Allen, aye. Bates? Bates, no. Gaines? Gaines, no. Galgiani? Galgiani, aye. Leyva? Leyva, aye. McGuire? McGuire, aye. Mendoza? Roth? Roth, aye. Wachowski? Aye.
Seven votes. We have 7 votes in favor, three opposed, and we got everybody here. So
Thank you so much.
Senator Cannella has asked that we take up the consent calendar, and we have a motion on that bill.
Senator Bell,
Yes.
unfortunately, I have to go and close out the committee that I chair,
Okay.
meeting.
We have other business.
Okay.
Senator Cannella makes a motion for the consent calendar. Call the roll, please.
The motion is do pass and refer to the Committee on Appropriations with recommendation to consent. Senator Bell?
Aye.
Bell, aye. Cannella?
Aye.
Cannella, aye. Allen? Allen, aye. Bates? Bates, aye. Gaines? Consent?
Consent.
Gaines, aye. Galgiani? Galgiani, aye. Leyva? Leyva, aye. McGuire? McGuire, aye. Mendoza? Roth? Roth, aye. Wachowski? Wachowski, aye.
Okay. That passes 10-0.
I move Senator Leyva's SB 1106 as well.
There's a motion to approve SB number 4, SB 1106. We call the roll, please.
The motion is do pass and refer to the Committee on Judiciary. Senator Bell?
Aye.
Bell, aye. Cannella?
Aye.
Cannella, aye. Allen? Allen, aye. Bates?
Aye.
Bates, aye. Gaines? Gaines, aye. Galgiani? Galgiani, aye. Leyva? McGuire? McGuire, aye. Mendoza? Mendoza, aye. Roth? Roth, aye. Wachowski? Wachowski, aye.
9-0. That passes on a 10-0 vote. And we'll leave it open for Senator Leyva to cast her vote. Senator Gaines? Where's Senator Gaines? Okay, Senator Gaines has a bill he's worked on, small check bill. Senator, would you like to present your bill now? Okay, Senator, I'll turn the floor over to you.